Hey guys, I really hope that you and your family is doing well in this challenging pandemic times, both physically and mentally. My name is Rishi Shekhar. I'm living in Mumbai and I'm a CA final student. The topic for this session is NCLT and NCLAT, which is a relatively small topic under corporate and economic laws of CA final group 1. Now, before starting off with this topic, I would like to give you a few insights as to what exactly these institutions are. NCLT and NCLAT, that is National Company Law Tribunal and National Company Law Appellate Tribunal, are the adjudicating authorities, that is the decision-making authorities for pending cases under provisions of Companies Act 1956, new cases under provisions of Companies Act 2013, and insolvency and bankruptcy code cases under Insolvency and Bankruptcy Code 2016. I hope you have got a light background behind your mind regarding as to what kind of subject matter we are going to learn in this topic. Now, for ease, I have divided this topic into four parts. One is I will tell you the number of sections to be covered. Second is I will explain you the hierarchy of judiciary. Third is I will explain you the terminologies to be learned properly. And fourth is I will be discussing and explaining the subject matter of the sections. I hope this is clear till now. Let's get started. There are about 14 sections to be covered, ranging from section 407 to section 434. But believe me, these are really very tiny sections for which you will not require that amount of time in understanding and learning. Hierarchy of judiciary. As you see on the screen, the first one is the Supreme Court. Under the Supreme Court comes the NCLAT. Under the NCLAT comes the NCLT. Now, let me take you back to school. You and your friend had a dispute. Where would you go to resolve? To the teacher. So your teacher becomes your NCLT. If after meeting the teacher you're not satisfied, what will you do? You go to the supervisor. Your supervisor becomes your NCLAT. Even after meeting with the supervisor, you're not happy with whatever solution she is giving. So you are going to the higher authority. That is your principal, and your principal becomes your Supreme Court. So in basic sense, hierarchy is the order of authority or order of judiciary. So in this case, the first is the NCLT. Then if things don't work, you go to the NCLAT. And if things don't work with NCLAT as well, you go to the Supreme Court. Now, you will have a question in your mind as to what is happening with the High Court, why it isn't there in this hierarchy of judiciary. The answer to your question will surely be answered, but not now in the upcoming slides. So hold your horses. Moving on. Terminologies, or you can say as definitions under section 407. So there are about 5 terminologies to be learned. They are quite simple. The first one is member. Whenever you read the word member in any of the subject matter of the upcoming sections, is member either judicial or technical of the NCLAT or the NCLT as the case may be. Now, after that is the technical member. A technical member means the technical member of the NCLT or the NCLAT as the case may be. Now, for appointing technical member, there are few guidelines which are given by the MCA for appointment. For example, a chartered accountant in practice for 15 years or more in experience can apply to the position. Similarly, in the case of cost accountant, and similarly in the case of company secretaries, and so on. I'm not going to go into that depth. Then, the judicial member. Judicial member means the judicial member of the NCLT or the NCLAT as the case may be. Now, in this case, a judge of the High Court can be the judicial member or any other guidelines as specified by the MCA. Now, the president. Now, president means the president of the NCLT. That means whenever you read the word president anywhere in the subject matter, it relates to the president of the NCLT and not the NCLAT. Similarly, when you're going to read chairperson, so chairperson means the chairperson of the NCLAT and not the NCLT. So these are specifically defined so that whenever you read these words in the subject matter, you can correlate them accordingly. Now, for president and the chairperson, there is one more point. The chairperson and the president cannot be addressed as the technical members of NCLT or the NCLAT as the case may be. The logic being that the position at which they have to be appointed has to be of a judge and not a technical member. So accordingly, they cannot be addressed by as a technical member. I hope you are understanding. Moving on. Section 420, Orders of the Tribunal. Now, this is a very small section divided into three parts. The first one says that the NCLT will pass an order after giving a reasonable opportunity of being heard. Now, what is a sufficient or reasonable opportunity of being heard is when you are going to give an opportunity for the parties involved in the case to pose their case in front of the tribunal, and accordingly, looking at the facts, the NCLT will pass the order. Now, in cases where there is a mistake apparent from record. So now what is mistake apparent from record? There is a factual error in the information given. For example, instead of 2 crores, the actual fact is 20 crores. So in that case, the NCLT has the power to rectify these mistakes apparent from record within 2 years. Within 2 years of the order being made available to the concerned parties. The application has to be given by the parties involved. However, there is one catch over here. Supposing in a scenario, the NCLT has given the order. Okay. Thereafter, either of the parties go to the NCLAT for appeal. So now in this case, the NCLT doesn't have the power to rectify the mistakes apparent from record because you're already appealed based on the facts given in the earlier order. So you cannot come back and now apply for a rectification regarding mistakes apparent from record to the NCLT. I hope this is clear. And the last point is very generic and very logical. Whatever the copy of order is going to be given, it has to be given to all the parties, concerned parties by the NCLT. Section 421, Appeal to NCLAT. Just as I explained to you earlier, if you're not happy with the teacher, to whom do you go? You go to the supervisor. So now in this case, the NCLT has passed an order. Either of the parties are not happy with whatever verdict they have given. So now they want to go to the NCLAT. So any party agreed from the order, they can go to appeal with NCLAT. But yeah, that is not going to be for an indefinite period of time. Like after 10 years, you're going to, come out from your sleep and say, okay, yeah, I want to go to NCLAT. No, that is not going to happen. There is a fixed timeline, and that is of 45 days from the date of which the order has been made available to the concerned parties. But still, they have given some relief. What if, due to some genuine reasons, you're not able to appeal within the specified time? The NCLAT will consider it, and it can be extended, but up to a maximum of 45 days. So how are you going to remember this? 45 days first, and then if you miss out, still it can be extended, but up to a maximum of 45. So 45 plus 45. Now, if an order from the NCLT has been passed after the consent of the concerned parties, you cannot go to the NCLAT. Now, if I explain with an example, you and your friends went to the teacher. Who is your teacher? Your teacher is NCLT. A teacher gave a brilliant solution. You and your friend liked it and settled for the same. But after that, your friend said, what if we go to the supervisor? We might get a better deal out of it. No, you cannot go to the supervisor because once the order has been passed by your teacher or the NCLT, and it is after your consent, is it after providing the information to you and you are consenting to it, like consenting means conforming to it, and you don't have any objection, you cannot go to the supervisor. That is not allowed. Then, what is the outcome of the order of the NCLAT? See, when you go to the NCLAT might reject the order completely given by the NCLT, or maybe modify the order given by the NCLT, or accept the order given by the NCLT. So either of these cases of outcome can be possible. And the fifth point is very generic and is very logical. The copy of the order of the NCLT will be given by the appellate tribunal to the NCLT and the concerned parties. I hope till now things are going smoothly in your end as well. Section 422, expeditious disposal. Now, expeditious is sounding very flamboyant. To make it easier, expeditious means a fast track, or you can say to do something speedily. So now the responsibility is also on these tribunals. The NCLT and the NCLAT should dispose the cases within 3 months from the date of such application. But yeah, however, in circumstances where they are not able to do it, they can still extend it, but for a fixed period of time, which shall not be greater than 90 days, with the permission of the president or the chairman. So you see now, here the president and the chairman word is there, but whenever you read president, you will read that it is the president of the NCLT and chairman as the chairman of the NCLAT. So that's how the logic goes over here. So yeah, after recording the reasons, they can extend it, but up to the 90 days. How are you going to remember 90 days for finishing off? And yeah, if it's not finished off in 90 days, then again plus 90 days. So there in cases of appealing to the NCLAT, it was 45, and then it can be extended to maximum of 45. Moving on. Section 423, appeal to Supreme Court. Now, what if you went to the supervisor? You're not happy. You're going to go to the higher authority, which is the principal. And in this case, it's the Supreme Court. So party agreed by order of NCLT can appeal to Supreme Court within a period of 60 days from the receipt of such order. The same can be extended again to a maximum of 60 days if sufficient reasons are shown and the Supreme Court feels it okay to extend. But again, it can be only for a maximum of 60 days. So how are you going to remember this? 60 plus 60. Now, when you are going to go to the principal, that is the Supreme Court, he has so many headaches, so many things to deal with. Now, if you go to the principal with some factual case like, it was 2000, but instead of 2000, they have written this 2 lakhs. This is not acceptable. The principal is going to say, I have appointed supervisors and teachers to deal with that. Why are you coming with a factual problem with me? Come with me for something like questions of law arising out of order. That means if there is some questions of law arising out of whatever the decision has been made by the order, then only you come to me, not for such factual cases. I hope this is clear. Moving on. Section 424, procedure before tribunal and appellate tribunal. So now, when I actually told you in the earlier slide why there is no high court, now actually I can relate and tell you as to why. But let me explain you the four points which has been given. In short, it is just trying to say that NCLT and NCLAT are independent courts and they have their own rights and they have their own power to govern their own regulations. So the first point is said, not bound by Code of Civil Procedure 1908. It's guided by the principles of natural justice and have powers to regulate their own procedures. Just trying to say that first, we are not going to be under Code of Civil Procedure 1908 or something like that. We are going to be governed by our own self. Then the second point is, it shall have the same powers vested in civil code under the Code of Civil Procedure 1908. This again means that whatever powers that civil code is enjoying, even I am going to enjoy under Code of Civil Procedure 1908. The third one is all proceedings shall be deemed to be judicial proceedings under IPC, that is the Indian Penal Code, and NCLT and NCLAT are deemed civil courts. That is what I was explaining. They are going to be, this section is trying to establish that yes, they are independent and they are not ruled by any other courts whatsoever, right? And now the fourth point is a general point, like whatever execution of orders by NCLT and NCLAT are given, they have to be treated as given by any other court, and it has to be sent to the local court of the jurisdiction of the registrar of company is situated, or a person concerned voluntarily resides or carries on business or personal works for gain. These two are the parties. The parties involved, maybe the concerned parties involved, who are going to go for appeal with these tribunals. So it is just trying to state that whenever a order has to be executed, it has to be submitted like it has been given by any other court, and then within the local limits of whose jurisdiction the register office of the company falls, or the person concerned, that is the party involved, who voluntarily resides or has this business or personal works for gain. I hope this is clear. This section is just a general person as to establish that yes, they are independent civil independent courts, and not just like any other court which has to follow the norms of any higher court. So yeah, coming back to the doubt of this hierarchy. So since they are themselves courts in their own sense, so it might be a logic of the law that since they are courts themselves, why to bring in the high court over here? In case of the earlier ones, where before NCLT and NCLAT, there was company law board. So in case of company law board, there was only one judiciary, and then it was allowed to go to the high court and then the Supreme Court. So now after new establishments of institutions like these, which are specifically dealing with these cases, it might have not been found prudent for again dragging high court into this. I hope this sounds clear to you all. Moving on. Section 425, power to punish for contempt. This means power to punish for disrespecting the court. So now if someone disrespects the decision, or make or if some parties come and actually abuse NCLT or NCLAT, they are having the same jurisdiction, the same powers and the same authorities, just as the high court is enjoying in case of contempt. And they can also exercise their powers which are contained in Contempt of Court Act 1971 and 1971. In short, it's just saying that if anyone is going to disrespect NCLT or the NCLAT, they are having the same powers as vested by high courts, and they can exercise their powers by Contempt of Court Act 1971. Okay, moving on. Section 426, delegation of powers. Now the NCLT or the NCLAT has the powers to give to its officers, its employees, or any person who has authority to inquire and report in the concerned subject matter through general or specific order, or as the case may be. Like they are having that power to appoint someone and give them some work, and then call upon some reports. It can be their employees, their officers, or any person who is authorized to do so. Moving on. Section 428, protection of action taken in good faith. Now it always happens then when any verdict is given and it creates a huge loss, but that loss is just because it is taken in good faith. So why the judicial power has to be penalized for it? So this section is like a protective right. So in this case, no suit, no prosecution, no legal proceedings shall be against the tribunals, its officers, or the employees, or whoever is involved in this case, because of any loss is caused or is to be caused by any judgment passed strictly under the provisions of the Act. Yes, of course, it's very, very logical, right? Just because it's a loss, you cannot see a judicial power to be a villain to someone, because it is taken in good faith. So this section is kind of a protective right to these tribunals. Moving on. Section 430, civil court not to have jurisdiction. Again, you can correlate this to section 424 of procedures of NCLT and NCLAT, that independence kind of concept. Again, they are going to tell you indirectly that the civil court is not having any jurisdiction to entertain any legal proceeding appeal to which NCLT, NCLAT is empowered to. That means whatever power NCLT and NCLT is having, there is none of the business of civil court. You are not going to come and touch us. That is what they are going to, trying to tell it in this section, that we are there, we are independent, we do our job, you don't come and meddle with us. So yeah, so again, so no injunction shall be granted by any of the court for the actions taken by NCLT or NCLAT. Now, first of all, injunction means a warning order. For example, NCLT or the NCLAT may have taken some action, may have taken some order. For example, give the concerned party a compensation of 2 crores within 40 days. That is the order given by either of the institution. Now, no other court has the right to, poke him or give them a warning order, maybe an extension of, maybe have an extension of 2 years, or maybe have lesser compensation, anything of that sort. No means no. You don't meddle with NCLT or the NCLAT. They know their job. That is what indirectly this section is telling all about. Moving on. Section 431, vacancy not to invalidate acts or proceedings. Now, this is just simply telling that in cases where there is going to be a vacancy or a defect in the constitution of the NCLT or the NCLAT, that doesn't mean the proceedings will become invalid. For example, if some 2 teachers are appointed in your class to come on any day, for example, Monday, but instead of 2 teachers, 1 teacher comes and explains you a concept. You cannot go and tell the next day, boss, 2 teachers were going to come, only 1 teacher came. You cannot complain because the topic has already been explained in the same manner. So when the proceedings are going to be legitimate, just because there is a defect in the constitution, no one is actually going to tell them that is not a valid act by the tribunal. It doesn't really affect any judgment or any proceedings carried on by these institutions. I hope this is clear till now. Section 432, right to legal representation. Just as we have so many options in case of income tax as well, like the chartered accountant can represent the assessees. In the similar way, the representation can be by the party by himself, or by the chartered accountant or chartered accountants, company secretaries, cost accountant or cost accountants, legal practitioners or legal practitioners, or any other person as authorized. Which means there is not any exhaustive list as to any limitations. Like if any person is legitimately authorized, they can also represent themselves to be in this case with respect to either of the tribunals. Yeah. Moving ahead. Section 433, limitations. So this is just telling that whatever limitations are going to be governed by, it are to be governed by the provisions of Limitations Act 1963. Like it shall apply mutatis mutandis, like as it is, to appeals and proceedings before NCLT or NCLAT, as the case may be. In short, it's just trying to say that whatever limitations provisions are going to be governed upon, it has to be taken from Limitations Act 1963. Right. Now, coming to the last section, I would say this is pre-era. Like pre-era, we are learning till now the post-era things. Now, what of all the cases which were pre-era, that means when the company law board existed. So to start off with this section, I would say every authority is with the central government. For example, in the first point, the date on which the cases have to be transferred from the CLB to the tribunals, it will be decided by the central government. The second point, all the matters, proceedings, or pending cases before the company law board immediately before such date shall be transferred to the tribunals, and they shall dispose the same under the provisions of the act. Like whatever the matters, proceedings, whatever it was there with the CLB, it will be transferred, and the cases transferred to the tribunals, and the cases will be disposed of with the tribunals by the tribunals accordingly. Now, in the third point, what if there are cases which have already been completed by the CLB and the order has been given? So now you cannot turn on to NCLAT for that, because you are already existing in the pre-era situation. So in those cases, the aggrieved party have to go to the High Court only, and within 60 days from the date where the document was made available to the concerned party. Now, in this case, again, there is an extension of period, and I can guarantee you that you can easily guess what might be the extension period without looking at the screen. Of course, it is 60 days. The same logic, 45 plus 45, then 3 months plus 90 days. Now here it's 60 plus 16. Same in the case of Supreme Court, it was 60 plus 60. So here again, the same logic. It can be extended by if the High Court feels that the reasons are really valid, and it can extend, but up to a period of 60 days. Right. So now let us come to something of the 1956 Companies Act. So all the proceedings, remember in the starting, I told you something about the pending cases to be transferred. So pending cases under the provisions of Companies Act 1956. So yeah, the same is stated over here. So all the proceedings under Companies Act, including arbitration, compromise, arrangements, reconstructions, or winding up, shall be transferred to the tribunals and disposed of thereafter. But in case of winding up, only such proceedings shall be transferred to tribunal that are at a stage as prescribed in the as prescribed by the central government. So, for example, central government can maybe have come up with a notification that whatever winding up is in stage 2 or stage 3, only those can be transferred. Rest maybe cases where it are in the last stage, it has to be wound up by the CLB and so on. Now, the last point over here is the authority is with the central government to make rules strictly under the provisions of this act for transfer of matters, proceedings, or pending cases of the company law mode. In short, they are just trying to say that the central government has the authority to make rules regarding the transfer of the cases from CLB to the tribunals. And the last one is thank you. Thank you for giving your time. I really hope that this will be a stimulator for you to learn this topic. At a personal level, I don't see questions from this topic for a huge amount of marks, but maybe this topic is really important for MCQs. So in my opinion, you can start learning this topic with respect to MCQs perspective, and when actually you have an additional time, you can actually learn this topic in depth. I really hope you guys are doing good at your home, your family is good, because these are challenging times which are going around. Stay safe, stay healthy, keep studying. I really wish you all the best. Thank you.